Welcome to the final round of the 2021 Herbert Weschler National Criminal Law Moot Court Competition. The Buffalo Moot Court Board would like to thank the judges for volunteering their time to make this competition possible. The judges for this round are Judge Paul L. Friedman, Senior U.S. District Court Judge of the District of Columbia, presiding. Justice Aaron M. Perodato, Associate Justice of the New York Appellate Division, 4th Department, and Dean Aviva Abramovsky, Dean of the University of Buffalo School of Law. Today, the contestants will be arguing the case of Sullivan v. New Erie. The round will begin with arguments from the petitioner, represented by the team of Heather Globerman and Diego Wright. It will continue with arguments from the respondents, represented by the team of Aaron Bartenstein and Ashley Johnson. It will conclude with the rebuttal by the petitioners. We will now start the round. Oyez, oyez. United States Supreme Court is now in session. Presiding are the Honorable Justices Friedman, Perodato, and Abramovsky, hearing the case of Sullivan v. New Erie.
Chief Justice, may I proceed?
Well, good afternoon, everybody, and we'll hear first from petitioner, Ms. Globerman.
Thank you. Chief Justice, your honors, and may it please the court. My name is Heather Globerman, and I, along with my co-counsel, Diego Wright, will be representing the petitioner, Ms. Samantha Sullivan. I will be addressing the issues of if the Fifth Amendment privilege applies and if the foregone conclusion exception is applicable. This is a case about one of the most personal and pervasive aspects of modern society, the protected nature of one's cell phone, and whether the Fifth Amendment can be narrowed to allow the compelled production of the phone's passcode. The opinion of the Supreme Court of New Erie should be reversed for 3 reasons. First, the Fifth Amendment privilege does protect the compelled production of a phone's passcode. Second, the foregone conclusion exception does not apply to personal records as opposed to business records. And third, any application of the exception to the novel digital context of smartphones would be unworkable. Beginning with the Fifth Amendment privilege against self-incrimination, what is at issue in this case is whether the compelled production of a phone's passcode is a testimonial communication or act. While communications may be, and often are, oral or verbal, this court has made clear in cases such as Doe versus United States, also known as Doe 2, that the
let me interrupt you right now. Sorry, I had not unmuted my phone. So why is producing a passcode a testimonial act when producing a key or a fingerprint is not?
Well, Your Honor, there are 2 different aspects that make an act testimonial. First is implicit assertions of fact, and second, as this court noted in Hubble versus United States versus Hubble, it involves the use of the contents of one's mind to assist the prosecution. And in your hypothetical, that is especially important here, because the use of one's mind to produce a key is simply to, say, take a key out of one's pocket and hand it to law enforcement.
Well, is the mental process in producing a passcode really any much more involved than that?
Well, Your Honor, first off, we would like to highlight that in United States versus Hubble.
Well, Hubble was very different, wasn't it? In Hubble, Associate Attorney General Hubble had already gotten immunity and was sort of cooperating with everybody, and they sent him back to go through thousands of pages of files to produce certain kinds of documents and files. Now, clearly there he was using his mind. Isn't a passcode with 5 or 6 or 10 numbers a lot different from what was going on in Hubble?
Your Honor, while it is true that the facts differ here, the important part and the holding of Hubble is that what made that act testimonial was not the amount of use that Hubble had to engage in, but rather the fact that he used the contents of his mind to tell the government something they did not already know, which is the very definition of a testimonial act. And the fact that this does not really have to be extensive or complicated is further illustrated by the precedents of this court, such as Pennsylvania versus Muniz. In that case, this court found that the answer to the question, "What is your 6th birthday?" was in fact a testimonial response, even though one's 6th birthday is also a simple string of numbers or letters, depending on the form. It is very basic information, but nonetheless, it was testimonial. So even though a passcode may not be the same as what happened in Hubble, that does not prevent this from being a testimonial communication or act under the precedents of this court. And in fact, it's actually far more analogous to specifically in Hubble, the analogy of providing the combination to a safe, which this court said would be testimonial, as requiring the use of the contents of one's mind to assist the prosecution. The fact that these productions are highly analogous has been noted by lower courts as well, such as the 4th District Court of Appeal of Florida in GAQL versus State, which found that a majority of courts has agreed that these acts are highly analogous, and as such, the production of a phone's passcode or a computer encryption key would be testimonial for Fifth Amendment purposes.
Would you be making the same argument if we were talking about a valid search warrant for the defendant's home, where the home had a keyless entry system requiring a passcode?
Your Honor, it would depend on the specific circumstances, but if it wasn't, say, written down on a piece of paper that could be compelled by a warrant or court order and that was voluntarily created beforehand, then yes, we could be dealing with a very similar circumstance.
Why is that so? In the case of the search warrant that Justice Paradato was talking about, they've already gone to a judge or a magistrate, and that judge or magistrate has said there's probable cause to go to the home. In this case, there may not be probable cause at all yet. There's not probable cause yet to search the contents, is there? But going to the home, they already have a judge saying you can enter that home.
Your Honor, I understand the question, and 2 points in response. First off, the petitioner acknowledges that the state of New Erie has actually obtained a lawfully issued warrant, and that is not actually at issue here. But the difference between the Fourth and the Fifth Amendments, especially, is that the Fourth Amendment protects against the rifling through one's belongings. But the Fifth Amendment protects against the rifling through one's mind. So even to provide the passcode to get into a passcode protected home, if law enforcement does not already know it, could be using the contents of one's mind to tell law enforcement information that they do not already know.
Well, that kind of leads to your next argument, doesn't it, a little bit? So hasn't the government established that the defendant does know this information, that the defendant knows the passcode, and is able to access the phone using that passcode?
No, Your Honor, they have not. As you can see on page 7 of the record, the evidence adduced by the state of New Erie to this point is frankly inconclusive. The nurse did not actually see the screen of the phone, and as Ms. Sullivan had just been in a horrific car accident, we honestly don't know what state of mind she was in or what medication she may have been on. Additionally, on page 5 of the record, she provided other information that could explain how she came to possess the phone as well.
Your point is that there's maybe some evidence that establishes the defendant is aware of the passcode and can access the phone, but it hasn't been conclusively established?
It has not been established to a degree of reasonable particularity, and this is key here because the production of a phone's passcode provides implicit testimonial assertions that give information relevant to the government's case. As the District Court for the Eastern District of Michigan explained in the passcode production case United States versus Kirshner, Ms. Sullivan is being compelled to divulge through her mental process the passcode, and as such communicate to the government at minimum 3 things. She knows the passcode, the files on the device exist, and she possessed those files. This is different than any other evidence the state has been able to adduce thus far, as in Hubble, it is essentially an affirmative answer to interrogatories by the state. What they have is inconclusive. What they're asking for would get them all the way there. The state is essentially asking this court to narrow the protections of a constitutional right because it's convenient for them, so they don't have to do the legwork. But because the production of the passcode does require the recall and use of Ms. Sullivan's mind, and does provide these implicit factual assertions that communicate information relevant to the government's case, as in Commonwealth versus Davis from the Pennsylvania Supreme Court, this production would be testimonial for Fifth Amendment purposes.
What's the government's alternative? What's law enforcement's alternative to get into somebody's cell phone? Even if they've got probable cause, you're saying they can't get into it.
Your Honor, there are still several ways that law enforcement can access the contents of cell phones in order to execute warrants. For instance, they can contract with third-party companies to hack or crack passcodes, or they can reach
They're
out.
very willing to do that. History has shown.
Or, Your Honor, they could also reach out to third-party manufacturers such as Apple, as was done by the FBI in the San Bernardino shooting case. Or they could subpoena third-party companies such as Snapchat or Facebook for the messaging records that they seek. The phone is not the only method at getting at this information. It's simply the only method the state of New Erie has tried. And as to my second point, that the foregone conclusion exception does not apply to matters of a personal nature, it is of note that this court has never applied the foregone conclusion exception outside of the narrow context of business or financial records. In fact, upon formulating this exception almost half a century ago in Fisher versus United States, this court then stated reservations about such an application, noting in footnote 7 of the opinion that special problems of privacy could be presented by subpoena of a personal diary. And at least 4 circuit courts do share this concern, that being the first.
Right. I'm surprised that you're citing Fisher at all from your perspective. I mean, why should we be listening to Fisher at all as precedent? How is it possible that a case decided back in an analog age, talking about physical documents of paper, has any bearing on the testimonial issue of the Fifth Amendment when discussing what is really information, right, that's held in a cell phone? Especially considering and if you could go into that, the distinction between the nature of a physical document and information on a phone. Why does Fisher apply at all?
Of course, Your Honor. Fisher applies because Fisher is the case that created the exception the state seeks to apply. So it is of note that even in that case, this court said that they honestly weren't sure that the exception could apply to matters of a personal nature, like what you would find in a cell phone. And this concern has been echoed by the First, Third, Sixth, and Eighth Circuits, who have all refused to apply the exception to personal matters. And this is very much of note because of the difference, as you noted, Your Honor, between hard copy documents and a cell phone. While it's true that the concern in Fisher was a diary, and the concern in many other cases.
So that's my argument for you. Are you resting your argument on the fact that it's personal information on a cell phone, as opposed to what I'm not arguing, but I'm asking you, could you simply say that these aren't documents at all and that Fisher is just inapplicable since it was done in a pre-internet age?
Your Honor, it is also our standpoint, and that is actually my third point, that the exception is inapplicable because this is a digital context. But it is also worth noting, as to my second point, that because this is a very personal context, the exception should also not apply for that reason. A modern smartphone is far more personal in nature than a simple diary, which was the court's concern in Fisher. In fact, a modern smartphone provides access to far more personal, private information, including medical records. And as this court noted in Riley, it provides a far more invasive look into the owner's life as well than a personal calendar or date book, because the geolocation data can be used to reconstruct the owner's movements down to the minute, not only around town, but also within a particular building. As such, a cell phone is essentially a record of nearly every aspect of one's life, from the mundane to the intimate. The court
Does it matter to you that they chose to do a passcode? I mean, that's another issue. Putting on a passcode means that someone has chosen to protect information with other chosen information. Is that relevant to your argument?
No, it is not, Your Honor, because it is still information that is known only in the holder's mind. So it would still require the divulging of the contents of one's mind to assist the prosecution in getting into a wealth of personal, private information, and in a context where this exception simply does not fit. And that brings me to my third and final point, that in the modern context of cell phones, there are complex characteristics that would make any attempt at applying this exception simply unworkable. First off, as this court noted in Riley, cell phones differ from other objects in both a quantitative and a qualitative sense, in that they are essentially mini computers that have the capacity to be used as telephones. And as the Supreme Court of Indiana further elaborated in CO versus State, 2019's top-selling model of smartphone can hold over 4 million pages of information. That's more than 300 times the number of pages produced in Hubble. And the result of this is that when one produces an unlocked smartphone for a law enforcement search, law enforcement gets access to everything on the device, not just those items it can identify with reasonable particularity. And while it is of note that the standard the government must meet in this context is basically a dead letter, there are other technological complications, such as cloud computing, that further complicate this issue, such as by the fact that because of cloud computing, the data a user views on the device may not in fact even be stored on the device, and law enforcement may not realize this until they've already read and investigated the information. For these reasons, we respectfully request this court reverse the opinion of the Supreme Court of New Erie. Thank you.
Very good. You made it in under your time. Chief Justice Rehnquist used to interrupt people mid-sentence. I wasn't going to do that, but I was getting close. Mr. Wright, I think you're up.
Thank you, Your Honor. Chief Justice, Your Honors, and may it please the court. My name is Diego Wright, and I represent the petitioner, Ms. Samantha Sullivan. I will be addressing the second question on how to satisfy the foregone conclusion doctrine. Cell phones are devices that contain vastly more private and intimate information than any that have ever existed. Narrowing the Fifth Amendment right against self-incrimination such that the government may easily compel a person to produce the contents of these devices would be an injurious result to the citizens of this country. We ask that the decision of the Supreme Court of New Erie be reversed for two reasons. First, the foregone conclusion doctrine applied here can only be satisfied by demonstrating knowledge with reasonable particularity of the contents of the cell phone, a burden that the respondent has failed to meet. And second, applying the doctrine in this way would not unduly burden law enforcement in their ability to conduct investigations.
Sorry, is that actually true that it has to be focused on what's in the cell phone, the foregone conclusion, as opposed to the foregone conclusion is the nature of just the password? Now, again, feel free to articulate to us all aspects of Fisher's appropriateness or not, but is that actually correct, what you're in the foregone conclusion argument you're making? Is there
Yes,
not a distinction? Yeah.
Well, yes, Your Honor, it is correct that if we are to apply the foregone conclusion doctrine here to satisfy it, the respondent must demonstrate knowledge of the contents of the cell phone. And this is for
is there a similar requirement, or would there be a similar requirement if the government was compelling the defendant to produce, for example, a key to her filing cabinet? Would the government have to make the same showing?
Your Honor, in that case, there is a distinction, as my co-counsel made earlier, between keys and combinations to a wall safe. So in that case, this court has held previously that producing a key is not necessarily a testimonial act, and so the foregone conclusion doctrine wouldn't even apply in that case. The difference here is, and then there's two reasons primarily why the focus of this doctrine should be on the contents of the phone, and that is this court's the first one is this court's precedent. The Fisher Court created this doctrine in the context of taxpayer records. And in every subsequent case, this court has heard similar sorts of documents have been considered, business documents or bank documents. Outside of this context, courts have had a lot of trouble in actually applying the doctrine. And that's why we have the split among the states and the circuits. So looking at the doctrine and what physically happens in it, there are two mechanical elements. There is the physical act of production, and there is that which is ultimately produced by that act. The Supreme Court of Indiana in COV State said that the act of production links this physical act to the documents ultimately produced.
So can I just ask a question? Are you conceding the idea that the information on the cell phone is in fact documents? Because I thought your co-counsel was arguing that they are distinct.
Your Honor, apologies. I'm using documents sort of as a shorthand term. There's all sorts of information, as my co-counsel correctly noted. There's certainly digital documents, there are text messages, photos, geolocation data, and all sorts of other things on a phone. And it does implicate different concerns with regards to just like documents, as were the case in Fisher and Hubble. but continuing, and I'll try to keep my language more precise about that. Consider the act of production a door opening that allows the government access to the treasure that they ultimately seek. So in Fisher,
so let me just interrupt you right there. Let's say it is a door opening.
Mhm.
Key is a door opening. Using the fingerprint is a door opening. Facial recognition is a door opening. None of those other three things, though, require the same showing that you are requiring with respect to the passcode. Why is that, and why is that an appropriate test with respect to the passcode?
Your Honor, the case of biometrics and that sort of thing is actually is a point that our argument doesn't ultimately rest on, but the second part of why the doctrine should apply to the contents of the phone may implicate that distinction shouldn't be the case, because entering in a passcode or putting your fingerprint on the scanner or holding your face up fundamentally is the same act of production if we're to treat it in that way. At the end of the day, the phone.
Don't you have a problem, Mr. Wright, if we go down that road? We're soon going to be with iPhones that won't need passcodes. We're just going to have facial recognition or fingerprints. We've got a whole line of cases that says it is not a violation of the Fifth Amendment to require you to give a blood sample, to require you to stand in a lineup, to require you to give your fingerprints. If we adopt your approach, don't we have to overrule all of that?
Not necessarily, Your Honor, but our approach would make the distinction that the act of unlocking a phone via whatever means implicitly communicates some information, especially depending on the context in which that act takes place. So a blood sample, you do not use your mind in any way to describe any of the information that comes from.
But putting your fingerprint up against a phone or having a phone take a picture of your face, are you using your mind?
Your Honor, you're not using your mind at that moment to unlock the phone, but what's implicated there is in fact the testimony implicit in unlocking the phone. And that is the second reason why in this context, the foregone conclusion doctrine requires demonstrating knowledge of the contents of the phone. And it's what the act itself tacitly communicates. And this gets to the heart of Fifth Amendment protections, which is protecting against self-incriminating testimony. Now, here in any of these cases, we don't have a written or a verbal statement. What we have is an act. And so to understand what that act communicates, we must necessarily make some inferences about it. And to make these inferences, we have to consider the circumstances and the context in which the act takes place. So for example, take the act of raising your hand. If you do this in the classroom in response to a question by the professor would understand you to be communicating that you have a response, perhaps an answer to their question. But if you raise your hand on Fifth Avenue at rush hour, you're hailing a taxi. It's the same act, but the communication implicit in the act is completely different depending on the context in which that act takes place. This is critical in understanding what is communicated by the act. And so here we must understand what the context is. In this case, the respondent has charged Ms. Sullivan with distribution and delivery of methamphetamine and has obtained 2 search warrants, in fact, to try and search through the phone, presumably because they believe there to be evidence related to these charges that they can use in their investigation of Ms. Sullivan. In this context, the act of unlocking the phone would take those accusations and affirm them for the police. The act would say, I do know the passcode to this phone. The contents you seek on the phone do exist, and I have control or possession of them. I put them there. These communications would serve or furnish a link in the chain of evidence necessary for the government to prosecute Ms. Sullivan. And for that reason, in order to satisfy the foregone conclusion doctrine and to compel production of the passcode, the government has to demonstrate that it already knows these communicative elements of the act. That brings me to the burden.
How do you propose that the government satisfy that showing? For example, knowing what files and documents are contained in the phone.
Sure thing, Your Honor. There are plenty of alternative means by which the government may learn about what's on the phone. The simplest of this is simply to ask somebody else who's had contact with Ms. Sullivan. This is what the police in State v. Andrews did, a case recently before the Supreme Court of New Jersey. They had information from the recipient of the text messages and photos of the defendant there, who was able to say, I got these text messages from Officer Andrews. I got these photos. With that information, the police then obtained a communication data warrant, which further corroborated their information that they already had. So in that case, before the government even made the motion to compel production of the passcode, they already had particular knowledge of the text messages and of the photos they expected to find on the phone. And another important.
So can I just ask a question? So you're saying that it's not affecting, in your opinion, not affecting law enforcement because the government, they'll have capacity to get the information and elsewhere. What's really at issue here with the Fifth Amendment is whether or not the quicker method by which the person has to give their authentication is somehow wrong constitutionally, even if the result will be the same in the investigation, but the evidence will eventually come out. Is that right? That there's something inherently different to being part of what authenticates or unlocks information that can then be used against you.
That's correct, Your Honor. And it is the protection of the Fifth Amendment, which prevents somebody from being used to testify against themselves. Even if the government caught a murderer just after the act with the knife in his hand and they asked him, did you do this? His Fifth Amendment right still applies, even though the evidence is already there, obtained by some other means. So just because, yes. So yes, to answer your question, yes, that is what we were saying here, that though this may slightly burden law enforcement in this area, causing them to, by other means, get this information, it is not an undue burden. They have alternative means.
Let me ask you this question. So you gave an example of talking to somebody else who received the text message. So that might indicate that an individual is selling drugs to this person or is engaged in a narcotics conspiracy with this person. And then the next thing law enforcement asks is, well, there must be scores of other customers. How do we find out about them? This might give them probable cause to seize the phone. Does it give them probable cause to go into the contents of the phone? And even if it does, you would say, yes, but they can't get the passcode. So it's an elusive victory for law enforcement.
Well, Your Honor, law enforcement does have the authority they obtained a lawful warrant to search through the phone. And if they want to attempt to crack the passcode, they're certainly free to do so. This is a way by which the passcode to the phone is essentially a sophisticated guessing method. Essentially, the passcode is just brute forced until it works. And this is a service that companies like Cellebrite, who the government turned to, this can be seen on page 4 of the record, provide. They have done so in the past as well. The FBI turned to Cellebrite in the San Bernardino attack in 2015, and it said, can you get us into this phone? And Cellebrite did. So though they have lawful access to the contents, what the government cannot do is compel someone to provide information the government does not already have. And in this case, they cannot compel Ms. Sullivan to unlock the phone because it would, in doing so, she would communicate information that the government does not have. I would like to turn briefly to the evidence that the government does have and why it fails to meet the burden of reasonable particularity. On page 4 of the record, an officer notices the phone in a purse next to Ms. Sullivan while she's recovering at the hospital. And later, a nurse who was subpoenaed to testify at the district court hearing of this motion testified to seeing on 2 occasions Ms. Sullivan make motions as if to unlock the phone and then go on to make texts and phone calls. Now, at best, this evidence may support a showing that Ms. Sullivan knows how to get into the phone. But this is not enough to meet the burden of reasonable particularity because
doesn't that evidence, I mean, the fact that it's in her purse certainly demonstrates control over the device. And the fact that she then is doing a text seems to indicate that she had the passcode and had the ability to use it.
Your Honor, the evidence may show that, but there's also reasonable belief to be had that the phone is Ms. Sullivan's daughter's or her husband. These are both reasonable things that we can infer from this evidence, but it is not conclusive. The state has not.
What evidence supports that reasonable belief as opposed to it just being speculation?
Well, it's the statements from Ms. Sullivan herself, Your Honor. She said that she has frequently accidentally taken her daughter's purse, which has her daughter's phone in it, or she's accidentally swapped her phone with her husband's. Now, of course, we don't know that this is exactly the case, but even if the evidence the government has makes a showing of control, it makes no showing of particularity with regards to any of the contents on the phone. And for that reason, it still must fail. The government has not demonstrated that it knows any particular text messages, any photos, any geolocation data, or any of the other things in its very broad search warrant through the phone. There is whatever reasonable particularity means, and it is a reasonable standard. We are nowhere near the line necessary to meet it in this case, and the government, for that reason, the motion compelling production of the passcode should fail. Now, to continue with, or to move on to my second point, which is that—
We've only got about a minute left.
Sure thing, Your Honor. I'll try to be quick. Law enforcement, as I said, has other methods to access some of the information within this phone. And as my co-counsel mentioned, an unlocked phone provides access to any cloud storage systems that may be on the phone, such as iCloud or Google Drive or something similar. The best thing to happen to law enforcement in the past 15 years was the decision by these phone manufacturers to put all of this information in the cloud, because that allows law enforcement to go to those manufacturers and say, hey, we have a search warrant, give us this information about this person. And there's been no attempt by the respondent in the record to do this sort of a thing. I see my time is up, Your Honor. May I briefly conclude?
Yes.
Thank you. For the foregoing reasons, we ask that the decision of the Supreme Court of New Erie be reversed and the motion compelling production of the passcode denied. Thank you.
Thank you. All right, we'll now hear from the respondent. And who's up first for the respondent?
Good afternoon, Chief Justice, and may it please the court. My name is Erin Bartenstein, along with my co-counsel, Ashley Johnson. I represent Team 28 and the respondent, the state of New Erie. We respectfully ask that this court affirm the lower court's decision. I will address the respondent's first issue, demonstrating that the petitioner has not met her burden of proving she has a Fifth Amendment privilege in the passcode. And further, that if this court disagrees, disclosure is warranted under the foregone conclusion doctrine. My co-counsel will address the respondent's second issue, demonstrating why the foregone conclusion doctrine applies here, because the state has met its burden of showing that a passcode exists and that petitioner knows that passcode. Your Honors, this case is about safeguarding the investigative process. Turning to respondent's first point.
Is your argument that in the absence of having, making this outside the scope of the Fifth Amendment, that law enforcement would not be able to get this type of information?
That's correct, Your Honor. And that's
usually how one would interpret safeguarding.
Yeah, that's correct, Your Honor. Per page 4 and 5 of the record, it's indicated here that when the state received the phone and saw that it was passcode protected, they went to the company Cellebrite and they asked for them to decrypt the phone. And they were told that there's no way to get into this phone without the passcode.
But is it not possible that in some situations law enforcement could get the same information even if they don't access the cell phone through the passcode? So what I'm asking you is your argument being based on the fact that the information on the cell phone cannot be retrieved in any other manner by investigative process?
That's correct, Your Honor, because even if that information was uploaded to something like the cloud, there's still going to be an encryption or decryption that needs to occur to be able to access those documents. Turning to respondent's first point, to invoke a Fifth Amendment privilege, the petitioner must demonstrate that 3 elements are present: compulsion, testimony, and incrimination. And I'll focus the majority of the argument on testimony and incrimination in response to petitioner's argument. Now, looking first to the issue of incrimination, petitioner refers to the language from this court's decision in Hubble that discusses information that's a link in the chain of evidence. Now, as Chief Justice noted, Hubble is a very different case than what's before the court today. In Hubble, the defendant was asked to sort through more than 13,000 pages of documents and categorize them into 11 different categories, which this court reasoned was the same as responding to an interrogatory or a deposition.
No, I know, but so really, aren't we kind of just talking about questions of degree, though? I mean, there's no question when the defendant gives this passcode, this is the link to maybe the same number of, or maybe the same amount of data that was involved in Hubble.
Your Honor, the information received from the defendant in Hubble was the first link in the chain of evidence. Here, the first link in the chain of evidence, as noted on page 4 of the record, was finding the defendant with drugs on her. The second link in the chain was finding her with drug distribution baggies and cash and other evidence of a drug trafficking ring. The third link in the chain of evidence was seeing a phone in her open purse. And the fourth link in the chain of evidence was having a nurse testify under oath to seeing Ms. Sullivan type a passcode into that phone and then use that phone on multiple occasions.
So all of that was sufficient to establish probable cause to issue the warrant for the information contained on the phone. But we're talking about the Fifth Amendment issue here with respect to the passcode. So why should the defendant be forced to turn that over? Why shouldn't we really overrule Fisher?
Your Honor, you're correct in noting that the state has a valid search warrant for the phone here, but this passcode has created a roadblock in getting to the evidence that it has a right to. Now, in Fisher, this court made a distinction between testimony and surrender. And today we're asking Ms. Sullivan to merely surrender the passcode so that the state can fulfill its investigatory duty.
There's this distinction between a key to a lockbox and a code to a safe on the wall, right? Can you get the code to the safe on the wall?
Well, per this court's, per Justice Stevens' dissent in the case of Doe 2, and then this court's dicta in Hubble, the defendant could not be compelled to provide a numerical code, but could be compelled to provide a physical key. Now, it's the state's position that that's an illogical distinction.
But it is a distinction that's been made previously by this court, which, so then are you also going to say that we were wrong and you should be able to get the combination to the safe, and you should be able to get the passcode, and you should be able to use the face and fingerprints for purposes for which we had never intended them in our earlier decisions to apply?
Well, Your Honor, per this court's previous Fifth Amendment decisions, there's no Fifth Amendment privilege in a voice exemplar. There's no Fifth Amendment privilege in a consent directive. There's no Fifth Amendment privilege in DNA or in blood samples. So to say that there suddenly is a Fifth Amendment privilege in a numerical code, when this court has already determined deeply personal information, has no Fifth Amendment privilege.
Other than forcing someone to sign a consent form, all of those other examples simply means to put your physical body someplace and not say a word in alignment, or to put your fingers down on an ink pad and not say a word. Aren't we going well beyond that?
No, Your Honor, 2 points in response. First, per the language of the motion to compel here found at page 5 of the record, Ms. Sullivan can secretly type in the code and then facilitate an open phone to the state. So she's not necessarily disclosing anything more than a physical act. Now, second, to make or continue to make a distinction between a physical thumbprint and a numerical code creates illogical and absurd results. For example, say there are 2 co-defendants in a case, and you had one who had their phone protected by a fingerprint and another by a passcode. It's not facilitating justice to say that one individual can be disclosing that information and the other is protected from it.
So why should we apply Fisher at all? In Hubble, they say if the act of producing subpoena documents conveys testimonial information that the documents existed where in the defendant's possession or control and were authentic, and the act of producing documents is a testimonial act. Is that not right? So how couldn't it be said then that all of these exist to authenticate? In fact, that's what the technology servers call this, an authentication process. Doesn't that then countervail the applicability of Fisher in this case?
No, Your Honor. Fisher requires 3 things to be present to invoke the foregone conclusion doctrine: existence, authenticity, and possession or control. And the state can prove each of those elements here. the state can certainly prove the existence of a passcode because when they received the phone, they tried to get into it and realized they couldn't because it was passcode protected. And the state can prove possession of the phone because it was found within Ms. Sullivan's open purse, and can prove possession and authenticity of a passcode because they subpoenaed a nurse who testified under oath to seeing Ms. Sullivan type in a passcode and then use that phone on multiple occasions.
But
So the foregone conclusion.
that's all that is required, you're going to be able to get the passcode in 99% of the cases that the government ever investigates, because you will stop a car or execute a search warrant and find the cell phone in somebody's purse or in their pocket or on their desk. And, someone will have seen him use a cell phone, or maybe that cell phone. You don't have to prove anything once you prove possession and the existence of the phone. I don't see how it protects any defendant if that's all that has to be shown.
Well, it certainly protects certain defendants, Your Honor. For example, if the state just found this phone lying somewhere in the hospital, it's not the state's position that they could go on a Cinderella glass slipper expedition to go up to every single person in the hospital and ask them to attempt to open the phone. Again, they must prove 3 specific elements: authenticity, existence, and possession or control. And because they did in this case, Ms. Sullivan simply doesn't have a Fifth Amendment privilege in the code.
I just have a question, because earlier you're saying in the safeguarding argument that they couldn't find this information any other way. So how could they have proved those elements if they didn't know what was in there? That the only way they could have known is if they had the passcode.
Your Honor, as this court stated in Doe versus United States, these are content-specific inquiries. So this court isn't considering the original search warrant for specific files on the defendant's phone, but rather considering the second motion, which is specifically for the passcode. Now, so long as the state can prove that a passcode exists and that the defendant knows that passcode, they have satisfied the foregone conclusion elements. Now, further, again, this case is about safeguarding the investigative process. And at the heart of the investigative process is the right to every man's evidence. In fact, that principle even predates the Constitution. It was first recognized in 1742, and it was last recognized by this court in 2020 in the case of Trump versus Vance. Now, what that states is that so long as the state is getting evidence in a way that does not trample over constitutional rights, they absolutely have a right to get that evidence and investigate and prosecute crimes.
So let me just clarify this for my own mind. So what you're arguing is that they didn't have knowledge of whatever was in the cell phone, and that doesn't matter. The only thing they needed to have had a foregone conclusion about is that a password existed, even if they didn't know exactly what it was, because they couldn't know that without asking the defendant. But that's enough for us to compel her to give it. Is that right?
Under the foregone conclusion doctrine, you're correct, Your Honor, that the focus is on the passcode. However, as indicated on page 3 of the record, the state does have a valid warrant to search and seize the phone. So to get that original warrant, they certainly had to establish probable cause for the underlying evidence they're seeking for those drug crimes and the drug trafficking crimes. That's why the warrant is limited in scope to things like text messages, social media, evidence consistent with investigating a drug trafficking ring.
Well, one of the things that I think is problematic is the following. When some of us were young, the only thing that existed were landline phones. And in order to get information from your landline phone, you needed a warrant to tap the phone. Because if you seized the phone, you wouldn't have anything except the physical instrument. And so the question really is, we are, under your approach, we are providing so much less protection to telephones than we did in the old days, when in fact they aren't really telephones, as the Chief Justice said in Riley, but rather they're everything in your life, from sexting to every contact you've had with any friend, to every store you've shopped at online, to your computer files, and your phone calls. And so aren't you, the government of the state, trying to apply case law that was developed a long, long time ago in a totally new context, where you're opening up virtually everything that used to be held private? And how do we apply the old case law? Shouldn't we be looking at a whole new approach?
No, Your Honor. Now, you mentioned the intimate details found within a phone, and that's true. However, in the context of a safe, which is a hypothetical this court has considered, you're certainly going to find intimate and private details about someone's life. Someone could store their diary in there, could store financial information in there, they could store family photo albums in there. And for this court to say that—
I had one question on that. Isn't one of the problems with the distinction of physical media and information this question of self-authenticating, right? That again, this distinction between a physical piece of paper does not authenticate itself, but by its nature, documents or data in a cell phone has a capacity to do that. Isn't that distinct in kind from all prior documents, and what we're metaphorically calling documents?
No, Your Honor, because if we're looking forward to trial when any information would be introduced, the state certainly still has to lay the foundation and evidence to introduce any of those documents. Now, the question here really is, should whether or not details are stored in a metal box in someone's closet in a safe be analyzed any differently than information stored in a metal box in someone's pocket? And the answer to that is no. Ms. Sullivan has no Fifth Amendment privilege in this passcode. Thank you.
Okay. So we're ready for Ms. Johnson.
Good afternoon, Mr. Chief Justice, Associate Justices, may it please the court. My name is Ashley Johnson, and I also represent the respondent, the state of New Erie. Today, I'll be addressing the second issue of this appeal. That is, what the government must actually show in order for the foregone conclusion doctrine to apply. And again, Your Honors, this case is about safeguarding the investigative process. And today I will be demonstrating two things. First, I will show that where the foregone conclusion doctrine applies, the government must only establish that a passcode exists and that the defendant knows that passcode. And second, I will show that if this court were to instead find that the government must establish the identity and contents of the cell phone, then this would hinder the government's ability to investigate and prosecute crimes, and it would not hold criminals accountable for their actions. Because the state knows that a passcode exists and that Ms. Sullivan knows that passcode, the passcode could be compelled under the foregone conclusion doctrine because there's no added testimonial evidence, and her Fifth Amendment right against self-incrimination would not be violated. Therefore, the state respectfully asks this court uphold the decision of the New Erie Supreme Court. Turning to the state's first point, in order for the foregone conclusion doctrine to apply, the government must only demonstrate that a passcode exists and that the defendant knows that passcode. And this court in Fisher v. United States generally established the foregone conclusion doctrine, but this court never established what the government must actually show in order for that doctrine to apply. But the doctrine was created as an exception to the Fifth Amendment or a carve-out, where if the government already knows something, then compelling that information would not violate a defendant's Fifth Amendment right against self-incrimination. And this court in Fisher v. United States stated that the Fifth Amendment protects against compelled self-incrimination, not the disclosure of private information. And for that reason, this court should find that the foregone conclusion doctrine applies to the passcode itself.
Has the foregone conclusion doctrine ever been applied to any context other than the Fisher context?
Your Honor, this court has addressed the foregone conclusion doctrine.
Has it ever protected any documents or information other than in the Fisher case itself? I know we've discussed it.
I'm sorry, what was that, Your Honor?
I know we've discussed Fisher, but has it ever been applied to protect documents and information or production of documents and information?
Not in this court, Your Honor, but there has been both a state and circuit split in addressing the foregone conclusion and what elements the government must establish. And while the 11th Circuit and Indiana Supreme Courts have stated that the government must establish the identity and contents of the cell phone, the Third Circuit and New Jersey Supreme Courts properly held that the government must only establish that a passcode exists and the defendant knows that passcode. And in State versus Andrews, the New Jersey Supreme Court stated that the focus should be on the knowledge of the existence of the passcode because there's a clear distinction between the act of producing a passcode and the documents to actually be produced. And if this court finds that the doctrine applies where the government can establish the identity and contents.
So maybe I can ask this in the inverse. Could you give me an example other than oral testimony where the Fifth Amendment, where you would consider something to come within the testimonial definition of the Fifth Amendment?
Your Honor, the Fifth Amendment or someone's Fifth Amendment right against self-incrimination would come where, for example, they're placed on a stand and have to answer questions that the government is asking them.
My point, other than direct testimony, other than being asked a question, do you have an example where the Fifth Amendment, where the testimonial privilege would apply in any other way, or do you believe there are no such other options?
No, Your Honor. If the government, for example, were to ask the defendant to write down or say something to them, that would be an example of a Fifth Amendment right against self-incrimination, and that would violate her Fifth Amendment right against self-incrimination.
So write down or say what to them? Anything other than a passcode? Like what's an example other than a passcode that you think they would write down that would be?
For example, admitting to a crime would be one such example. And this court should draw a distinction between the evidentiary object and its production. In this case, in the context of requesting a passcode, not in requesting the actual files or documents on the cell phone, because at the record of page 3, the state has already obtained a valid warrant. And in State versus Stahl, the Second District Court of Appeals of Florida held that the doctrine applies to passcode because this standard that the government must meet would simply apply equally to all types of passcode owners and phone owners based on the type of passcode that they choose. In addressing Commonwealth versus Davis in the dissent of the Pennsylvania Supreme Court, the dissent reasoned that the compulsion of a passcode is essentially an act of production. And the dissent explained that the appellant's computer files in that case were not the subject of the compulsion order, but the passcode itself was. And the same is true here, Your Honors. The appellant is simply being compelled to produce her passcode. So the government need not establish what actually exists or not. What actually exists on the phone itself, since that's not what is being compelled.
No, what is being compelled is the door that opens that opens all that information. To you, that doesn't matter.
Your Honor, again, it turns on whether or not it violates the defendant's Fifth Amendment right against self-incrimination. But compelling Ms. Sullivan to present her passcode would not violate her right against self-incrimination. But if this court disagrees, looking at the decision of this court in Fisher versus United States, again, this court stated that the Fifth Amendment protects against compelled self-incrimination, not the disclosure of private information. And because the government already knows that a passcode exists and that Ms. Sullivan knows that passcode, this would be a foregone conclusion and it would not violate her Fifth Amendment right against self-incrimination.
What would be a foregone conclusion?
Your Honor, it would be a foregone conclusion that a passcode exists and that she knows that passcode.
Okay, well, she will admit to you that she possesses the phone. She will admit to you that the passcode exists, and she will admit to you that she knows what the passcode is, but she asserts her Fifth Amendment privilege to provide it.
Your Honor, when the government is asking a defendant to provide their passcode, upon presenting their passcode, the only thing the defendant is saying is that a passcode exists and that they know that passcode. And because the government can't establish.
So I'm still a little confused though. I mean, isn't that what all testimony is about? I mean, frequently the government already knows what the defendant is being asked to say, and yet we allow them to retain their Fifth Amendment right against self-incrimination not to say it. So why is it distinct? Even if let's assume that the government had was making first this is speculation, right? Let's assume that they knew that there was a fact a passcode. Clearly, they don't know what the passcode is, so they're seeking evidence. But how is it distinct from any other forced testimony? Is really my question that I'm getting to.
Your Honor, the foregone conclusion doctrine serves as an exception to the Fifth Amendment, where if the government already knows of something, then compelling that from the defendant does not.
That's my question. But why? I mean, why shouldn't it apply to all oral testimony that the government knows? Like, once should we then be able to say you do not have a Fifth Amendment right because we have evidence of what you've done. So you must now answer the question.
Your Honor, this court has not addressed that in oral testimony,
We're addressing it right now.
but Your Honor, again, the government would have to establish in the context of a password that a passcode exists and the defendant knows that passcode. And this gets to the state's second point that this case presents a question that is a particularly unique and current issue that law enforcement's facing. And that question is how to adjust investigative processes to fit the digital era that we now find ourselves in. And again, this case is about safeguarding the investigative process. But if this court finds that the foregone conclusion doctrine applies where the government can establish the identity and contents of the cell phone, then this would hinder law enforcement's ability to investigate, thwart, and prosecute serious crime.
Well, you just have to be more creative. I mean, it may be time to just jettison Fisher completely, all of it, and to do what the Chief Justice suggested in Riley and in Carpenter and what Justice Sotomayor has suggested, that we're living in a new era and these are harder problems than before. And judges and lawyers and law enforcement have to get more creative and think about the new paradigm. And rather than try to fit square pegs into round holes. And I would suggest that maybe it's time for the government to do that.
Your Honor, if this court sets the bar far too high, requiring that the government establish the identity and contents of the cell phone, then this would limit law enforcement's ability to investigate crimes. Because the entire purpose.
So, but I mean, my question though is, I mean, is not that what the Fourth and Fifth Amendment are for, to limit the investigation of crimes?
Your Honor, the Fourth
As a
Amendment.
matter of civil liberties?
Your Honor, the Fourth Amendment serves as a protection against essentially privacy for a defendant, and the Fifth Amendment serves as a protection for a defendant not to be a witness against.
What about the 14th? It has some limiting effects also.
And Your Honor, again, the entire purpose of an investigation is to collect additional evidence to prosecute defendants. But if this court finds that the government must establish the identity and contents of the cell phone, this would create such a barrier that law enforcement wouldn't be able to properly acquire evidence for prosecution. And it would effectually yield absurd results. And if we were to consider the facts like those in State versus Stahl out of the Florida 2nd District Court of Appeals, in that case, the defendant was arrested after taking an inappropriate video of a woman. And when police arrested the defendant, they found a phone, had reason to believe that a passcode existed and that he knew that passcode. But if this court or the court there had held that the government had to establish the identity and contents of the cell phone, police's investigation would not have been able to move forward because police could not establish that was the specific phone used to take that video. And that's just one example of absurd results that would lead or be caused by the foregone conclusion bar being set far too high. However, if the foregone conclusion doctrine simply requires the government to establish that a passcode exists and that the defendant knows that passcode, then that would give the law enforcement the ability to fully and more effectively investigate a crime that the defendant is already suspected of having committed. Furthermore, the petitioner recognizes that this court addressed cell phones in Riley versus California. And while this court identified that cell phones are different from other types of documents, the court held that law enforcement needs to just get a warrant in order to search a phone. And that's exactly what the state did here. So this court should not essentially set such a high bar that law enforcement can't conduct their investigations. Furthermore, if this court finds that the foregone conclusion doctrine applies where the government can establish the identity and contents.
Can I just ask a question on that? So how easy does it have to be for the investigation? I mean, is that basically saying that the interest is that when doing investigation, everything must be made available to the police under all circumstances in every way? I mean, what types of things would you say are permissible burdens on investigators and police?
Your Honors,
why are they different from here? It's hard for me to determine what's absurd without having a spectrum of comparison.
Your Honor, the state's not asking this court to encroach on defendants' rights by forcing them to incriminate themselves. or rather that this court just not allow defendants to hide behind illegitimate barriers and prevent investigations. Furthermore, if this court sets the bar far too high, it would essentially render valid Fourth Amendment court orders virtually unenforceable. Here, the state already has a valid warrant.
That's just my question again. So the, passcode or facial recognition, whatever it is to unlock something, there is no, your argument is, or I'm just asking if your argument is that the facilitation of the investigation is the overriding interest of the state. Is that correct? Against the Fifth Amendment?
Your Honor, again, well, the state's not asking this court to encroach on rights, but simply allow law enforcement to conduct legitimate investigations. And furthermore, individuals with written passcodes would have far more protections than those with fingerprint or facial recognition passcodes. And these inconsistencies in the laws have been noted by many different courts. And individuals with bad intentions would likely opt to having written passcodes, and this should be a concern by this court. This court should create consistent laws to lead to predictable results for all types of passcodes. So by requiring just that the government establish a passcode exists and the defendant knows that passcode, this would create more equal protections. Whether turning over information violates the Fifth Amendment should never turn on the manner in which a defendant chooses to store that material. And again, Your Honors, we want to create predictable results. And the right balance can be made by holding that the foregone conclusion doctrine can be established if the government can show that a passcode exists and the defendant knows that passcode. And because the state meets these requirements, this would be a foregone conclusion. And therefore, the defendant's passcode could be compelled and our Fifth Amendment right against self-incrimination would not be violated. Therefore, the decision of the New Erie Supreme Court should be upheld in favor of the state. Thank you.
Thank you very much. And I think Ms. Gloverman reserved all of 1 minute for rebuttal.
Chief Justice, may I please proceed?
Yes.
1 point on rebuttal, Your Honor. The respondent has incredibly and unrealistically suggested that this court should view this motion in total isolation of what the state of New Erie actually seeks the production of. The state of New Erie does not want the mere content of Ms. Sullivan's passcode. They want what is beyond the passcode protected wall. They want the unlocked cell phone. This is essentially, as you can see on page 4 of the record, an unbounded amount of what could be millions of pages of personal, private information, ranging from videos and pictures to notes, data, and geolocation information to essentially any diary-like note stored on the phone.
Well, the court has already has already decided that they're entitled to that information.
Yes, Your Honor, but the way they are attempting to get it is essentially the functional equivalent of, as Judge Altamari explained in his opinion in State versus Stahl, prying open the lips of a witness. And I see my time has expired. May I finish answering your question and briefly conclude? Yes. And essentially eviscerating the intended power of the Fifth Amendment to protect the privacy of one's mind and to protect one from being compelled to be a witness against their self. And as the respondent admitted, all for law enforcement convenience. For these reasons, we respectfully request this court reverse the opinion of the Supreme Court of New Erie. Thank you.
Thank you very much, and thank all of you. The case is submitted. And somebody cracks a gavel and we're done.
At this time, the judges will complete their evaluations of the contestants. The results of the competition will be announced at an award ceremony later this evening. The Buffalo Moot Court Board would like to take this opportunity to acknowledge and thank all of those who made this year's competition possible, with special thanks to the final round judges, Judge Friedman, Justice Perodato, and Dean Abramowski, Don Skopinski, Christina Lively, each of the judges in the earlier rounds of the competition, the staff of the University at Buffalo Law IT Department, and the UB School of Law Advocacy Institute. The Herbert Weschler National Moot Court Competition is organized and produced by the Buffalo Moot Court Board under the supervision of the Advocacy Institute at the University of Buffalo School of Law. Thank you for watching the final round of the 2021 Herbert Weschler National Criminal Law Moot Court Competition.